Night and welcome to Legalize this 4th day of May 2025. And tonight we have a panel of truly eminent Caribbean people. We have Dr. Linton Lewis, uh, who is he has a doctorate in accountancy, I'm correct?
Law.
Doctorate in law, but he's also an accountant.
That's it.
All right. And we have Professor Robertson, Professor of Law. And we also have Mr. Francis Paul, who is the president of the Grenada Bar Association. And of course, there's my co-host, Ms. Aisha Mclean. But before we get into the business of the night, I just want to recognize the sponsors of this program, World Professional Solutions, Inc., Gem FM carrying this program on FM radio out in Canada, and Grenada Technical and Allied Workers Union, Cheetah.
At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Welcome back. Recently, can you just maybe put on the screen? Yes. Recently, on the 15th of April, the Caribbean Court of Justice celebrated its 20th anniversary. And I just want to start the program by referring to an excerpt from a speech given by the president of the court in an activity held at Boda campus, and in which Professor Robinson was one of the participants. He said this: the establishment of the CCJ is the most far-reaching, the most consequential decision ever made by the political directorate in the Caribbean community. I've heard it compared to the establishment of the West Indies Federation in 1958. But I vigorously disagree. That ill-conceived creature was always likely to fail. It was a construct devised by Whitehall in a manner to palliate restive West Indian nationalism. The Federation was a colonial entity whose Governor General, Lord Hales, was a British public servant in whom was vested all executive authority within the federal government. On the contrary, the CCJ was conceived and entirely constructed by us with input from the Caribbean people, and in particular from the Jamaican Bar Association. The CCJ is an authentic, autonomous vehicle designed to advance democracy and the rule of law in the Caribbean community. The CCJ was primed to succeed, and it has been precisely fulfilling its destiny. So today I give thanks to the leaders of the governments and the people of the Caribbean community who supported the establishment of the CCJ. In particular, I give thanks to the states of Barbados, Guyana, Belize, Dominica, and St. Lucia for fulfilling the treaty promises and for entrusting to the court the solemn responsibility of deciding the final appeals. With that said, I'm basically handing the program over to Mr. Paul and also to Aisha.
Well, good evening again, everyone. I would like to take the opportunity to thank Professor Robinson and Dr. Lewis both for being a part of the program this evening. Well, we are celebrating an anniversary, and I think on the occasion of an anniversary, we must always say congratulations. So, first, I wanted to start off by saying congratulations to the CCJ. 20 years. This is a major milestone. Just to get the ball rolling, let us give our viewers the opportunity to know the history of the court. And this is between Professor Robinson or Dr. Lewis. Either of you can answer. Can you give us a background towards the establishment of the CCJ?
Me or you, Mr.
You
Paul? Well, I think the first thing to say is that the CCJ is not the first of the regional courts. And as Grenadians and persons from the Eastern Caribbean has been a place where long before the Eastern Caribbean Supreme Court, there have been courts serving multiple jurisdictions. This particular court was spoken about well before our independence, but there's a pivotal moment in 1970 when the idea around Caribbean Court of Appeal concretizes and gathers steam and leads to the CCJ agreement in 2001 and the inauguration of the court in 2005. So I think of the CCJ as one of several types of regional courts we've had, but a very distinctive court. This is the one court which is our own and our own creation. And that's why the president is as autochthonous. Regional courts have included historically the Eastern Caribbean Supreme Court, were historically pragmatic arrangements, colonial arrangements for governance of smaller jurisdictions. The objectives of the CCJ are, of course, way more ambitious and deeply connected to our own self-development and self-determination.
Thank you so much, Professor Robinson. Dr. Lewis, would you like to add anything more about the establishment of the court?
Yes, just the uniqueness of its structure and configuration, in that you would notice, for example, the Supreme Court in the United States of America or the Supreme Court in the United Kingdom, insofar as the financing of those institutions are concerned, they don't have the same level of independence as you find existing in the CCJ. For example, there are three sections and there are two insulative bodies. The Regional Judicial Legal Services Commission, that has to do with the administration of the court, appointment of judges, and therefore that is separate, supposed to be separate and distinct from the court itself. And you have the Caribbean Court of Justice Trust Fund, of which I'm the chairman. And it is from there that the court gets its financing to actually be involved in the operations and the deliberations. Now, that is very important because we're in an institution, we're in a region, we're a people that sometimes feel very suspicious of our own. And we're so highly political that for the most part, everything that is done is political, or we see it as political. And to remove that sort of consciousness from our people into thinking that judgments have been given because they've been paid by the judges to give them, we had an insulative mechanism, and that is the Caribbean Court of Justice Trust Fund, which was established via the agreement, a revised agreement of the Caribbean Court of Justice Trust Fund, which became effective on the 27th of January 2004. And the manner in which it is funded is very interesting indeed, because the Caribbean Development Bank raised on behalf of countries in the Caribbean $99.5 million, and countries contributed in proportion to their GDP. One presumes the Eastern Caribbean countries were 2.11%. Now, in addition to that, there was what we call an interest on that 99.5 million of about 1.5 million, and the additional contributions from the Caribbean countries of 3.9 million took us to over 110 million. In addition to that, we had a contribution from the Bahamas. They contributed from 2006, I think, about $1 million. So in all, we had $114 million that we invested on behalf of the CARICOM countries. And our role really is to invest in tax efficient instruments to ensure that we realize income and capital to the extent whereby we're able to finance the Caribbean Court of Justice into perpetuity. We started effectively in around on the 1st of May 2004, and we were given the funds by the CDB sometime in 2005. So we have effectively been in operation for the past 19, almost 20 years. And we were given a milestone that we're supposed to achieve in order to finance the court. And that was, we were supposed to achieve 8.9% in our returns. 6% of that was supposed to assist in financing the court, and about 1% for managing the funds itself. Now, we have, I think we have done very well in that for 12 of those years, we have been able to exceed 8.9%, and by a long way for the most part. Only on 5 occasions we have had lots of negative returns. And if you can recall, in 2008, when we had a serious market crash, we had negative returns of 19.5%. But most institutions in the world did worse than we did here in the CCJ. And just about 2 occasions in which we didn't attain the 8.9%. As a result of that, we have been able to disburse to the court approximately $133 million. And we still have $75 million remaining. So that is remarkable. I mean, when it was first introduced and the finance were given, the intention was never to have that amount of money or be all that should be given to assist in the finance of the court. Understandably, $140 million to finance the court into perpetuity will not be reasonable at all, especially when the court is funded approximately $7 million. And I'm speaking about US dollars now, every year. So we have done remarkably well. And the board is composed or comprised of very highly skilled individuals, from the Secretary General of CARICOM on her nominee, the Vice Chancellor of the University of the West Indies, or nominee, the Caribbean Congress of Labor, who have the Institute of Chartered Accountants, the Institute of Insurance in the Caribbean, the Institute of Indigenous Banks, and also the indigenous, or for example, the Caribbean Industry and Commerce Association of Industry and Commerce. There are 9 of us really who sit on the board, and we deliberate as often as we can. We're structured in a way that we have a finance investment committee that deals specifically with finance investment. We also have the investment advisor who advises, Mercer advises the trust fund. We have an audit committee, and we also have a compensation committee. And so these subcommittees deliberate on very important things on finance, on investment, remuneration, and compensation for the organizations. It's actually well structured. And I think largely we are able to have a good relationship with the court. There's a protocol that's established between, or let's say, among the Regional Judicial Legal Services Commission, and also the Caribbean Court of Justice with the Caribbean Court of Justice Trust Fund. What we do is we determine how, when, and the circumstances under which we will make distributions. Also, how we will acquire finance, apart from that which is given by the heads of government. Understandably, we can't go out and seek funding that will create a conflict with the court, and we can't do so without the permission of the heads of government, the imprimatur. But we recognize that we are an international or quasi-international organization because the agreement was registered with the United Nations, signaling to the world that it's authentic and that at least any conflicts, the organs of the United Nations can be invoked to help to resolve them. So it is indeed a solid institution with privileges and immunities. And that, to my mind, largely determines the existence of the court, because without money, you cannot exist. There are challenges. There are challenges insofar as the fact that over 80% of the funds will go towards paying wages, salaries, and pensions. Now that is problematic because our judges sometimes, and hopefully, I don't want to wish anything ill on anyone. When they retire, they live longer than normal, and nothing's wrong with that. So you end up having two salaries to pay. You have a pension to pay, and you have the salary to pay. And the more judges come on, the more they retire, you're paying really a lot of people. So there has to be a mechanism introduced at some point in time that will assist the court to be able to deal with that issue far more effectively. I suppose at some point in time we will have the opportunity to discuss that with character, but we do have suggestions in place to minimize the rise in expenses as far as salaries and pensions are concerned. So we are part, and we are within and without the CCJ. We try to function separately. We have to understand the implications of not being in a position to finance support. We recognize that we need to have the funding sooner or later, because you speak about Western Federation, which I believe was at a different time, under different circumstances, and to the extent that we can compare them would have to be the effort that was made and the type of unity that was attempted. It was not just to establish a court which dealt with the rule of law. It was an attempt to bring the peoples of the Caribbean together, whether it was under colonial rule or under independence, but at least an attempt was made. And the attempt has still been made. We still have not been able to bring our people together as one nation, but we've been able to do it with the Caribbean Court of Justice, and we're very thankful for that.
Thank you so much, Dr. Lewis and Professor Robinson. I think that was a great introduction to the court. Francis, would you want to ask a question now? Because if you leave me alone, I would go on.
Yes, thank you. Good evening to all. Mr. Layne, thank you for inviting me to come on this program this evening. It's a very important topic, and I would like to thank Dr. Robinson and Professor Robinson and Dr. Lewis as well. I too want to congratulate the court on its 20th anniversary. For me, starting off, a lot of folks, the ordinary folks, do not know the functions of the court. Just even the magistrate court in Grenada and in the region, and the high court, how it works. So I know this being a higher court, an appellate court, I know that the ordinary man out there may not even know that there is something called the Caribbean Court of Justice. So what I want to ask Professor Robertson and or Dr. Lewis is to just give us a brief overview on the role of the CCJ.
Well, I could jump in here to begin, but I was really intrigued by Dr. Lewis's description of the role of the trust fund, because, as lawyers, we talk about two different jurisdictions of the court. It's a unique court. In fact, I can't think of any other court which is both an apex court, which hears appeals from Caribbean states, and also a court which is an international court with jurisdiction over the revised Treaty of Chaguaramas. And in that respect, it is the revised Treaty of Chaguaramas and the disputes which often end up before the court are often trade disputes. But very notably, there have been also cases about freedom of movement. So those are the two major jurisdictions. It hears appeals from the states which have accepted its appellate jurisdiction. It's an international court. But when I listened to Mr. Lewis, Dr. Lewis, I was really struck by how little we know about its organs, that it's an independent court, and great lengths were taken, and interventions by civil society, notably the Jamaica Bar Association, to strengthen the independence of the court. But the court itself has structures with measures of independence themselves, like the trust fund, and also the Regional Judicial and Legal Services Commission, that's responsible for a whole range of tasks related to the court. And these institutions are all important parts of the court and help us to understand how it works. Because the trust fund ensures the financial integrity and viability of the court and sustainability as a long-term project. The Service Commission, which is by far the most diverse service commission that exists in the Caribbean at the moment, really ensures the integrity of the appointment process and ensures that appropriate and qualified persons are appointed to the court, but also oversees a whole set of questions which relate to discipline and other matters and compensation of judicial officers. That these bodies are separate from the judges is important. Even though the president is the chair of the Service Commission, it's very important that it's not the president's service commission. There's a deputy chair, and there'll be moments where the deputy chair has to chair. And it includes a variety and diversity of persons represented from all around the Caribbean, including civil society. But when I take the institutions, we hear the jurisdiction, this twofold jurisdiction like no one else. These institutions, which are really integral to the independence and sustainability of the court. I also think about its way of operating. It has a strategic plan. Think of how many courts you know with a strategic plan, with a clear management plan and a way of thinking about how it needs to be run to be not only purveyors of justice, but to be efficient and effective in delivering justice as well. And so I think for me, it is understanding that the structure of the CCJ includes way more than the judges and the court and the decisions they make, and that it is an entire structure and set of institutions and way of working, which is designed to ensure efficiency, responsiveness, communications with us, and also to be able to do this work for a long time for the Caribbean. And that's, to me, the impressive accomplishment in its inception and its work over the last 20 years.
Professor Robertson, I certainly agree with you. I think I was also taken aback when Dr. Lewis began to explain the workings of the board. I did not know. I mean, we always knew that it was independent and we had these structures in place, but nevertheless, you didn't know exactly how it operated and to what magnitude. Persons would normally think of our region as a small region, and therefore we can't do much. But you know what they say, lickle, lickle, full basket. And obviously the basket is full. I may say it may be overflowing at this point in time. So thank you so much, Professor Robinson, for getting into the two roles that the CCJ plays. Dr. Lewis, while I have you here, I would like you to just delve in just a little bit more, because Professor Robinson, obviously, she stated that it's an apex court, and then it's a court that interprets the Treaty of Chaguaramas, making it an international court. So what I would like for you to do, Dr. Lewis, is if you could just expound a little bit more for our viewers. Explain, what does Professor Robinson mean when she said it's an apex court, it's an appellate court? Like Mr. Paul said, some persons don't understand how matters come from the magistrate court, and it could even reach to the Privy Council, the CCJ. And I would like for you to just delve in a little bit more.
Yes, thank you. Now, apex meaning, we all are aware of the Privy Council. That's our final court of appeal. And we call it our final appellate court for countries that are still tied to the Privy Council. For those that are actually tied to the CCJ, I think Dominica, Belize, Guyana, Trinidad, and St. Lucia recently.
Barbados as well.
Barbados, they actually have the CCJ as their final appellate court, which means that if you have a problem, be it in civil or criminal matters, that's a final court of appeal. Other territories that are not members of the appellate jurisdiction will go to the Privy Council still. The Grenada, Vincent, Antigua still go to the Privy Council for their final judgments. Now, insofar as the original jurisdiction is concerned, there's a treaty that binds trade within the CARICOM region. And that treaty has to be interpreted, and there may be times when institutions and states conduct their affairs in such a way that they contravene or breach the provisions of that treaty. Now, that's what we call the original jurisdiction. The matters can then be brought to the CCJ. And that's also the final court in its original jurisdiction. When it is referred to as an international court, now it's because it's dealing with different countries insofar as the original jurisdiction is concerned, resolving treaty matters. It has an international essence of an international institution. Now, in its original jurisdiction, I think only about 34 or just over 34 cases have been heard, and in its appellate jurisdiction, over 305 or so have been heard. So it is still new. The judges are still out there trying to make that impression, because as you know, in the Caribbean, it's not very easy to impress and to remove a sort of consciousness that we have had for many years as to what is good, what is best, and what is better. And so it's a very hard task to be able to establish that Caribbean jurisdiction. But we understand how we exist, we understand how we live, we understand how we do things here in the Caribbean. And then we need to use that sort of social or socioeconomic existence to be able to impose it on the judgments that we give, understanding the way the people here live is different. Some people say when they're very far away, as in the Privy Council, they're more objective, but some people also say that they don't understand precisely the sort of culture of our people, and therefore the jurisprudence, may be problematic. But the courts so far seem to be very impressive in some of the judgments. Shanik Mary judgment in particular, that one seemed to have pervaded the Caribbean and indicated to people that the CCJ is still in existence. So it has its benefits, and one hopes that after a period of time, other countries may see the need to recognize not only the judgment, but recognize the jurisprudence, and also the fact that it may be necessary to have this institution helping us to relieve ourselves of colonial sort of dependency. I don't really want to go into the historical aspects of it because I'm more about merit and ability. And we have to be very careful about something that's very important. I've been around the Caribbean, a few islands, arguing for some of those islands to come on to the CCJ. And there's one thing that seems to have been very important in the minds and crucial in the minds of people, and that was whether or not the judges will be biased, whether or not they're capable because of their own experiences within their respective countries in the OECS, for example. Sometimes we have to learn to temper justice with mercy. Sometimes in our attempt to be pure and holy, we miss merit at times. And even when we are appointing judges in the respective territories, we need to look at people who have the ability, not necessarily those that we like, and those we have a sort of bias towards, but ability. The OECS seemed to have gone ahead, and we employ judges from different countries in the Caribbean. I'm not sure if other countries do the same, with the same liberty and openness. But all of those very fundamental issues would have a lot to do with the existence of the Caribbean Court of Justice. And we also have to recognize that we have talent also here. In the Supreme Court in America, you see people from America. In the Supreme Court in Britain, you see people from Britain. And you don't have to go far. We have people who are extremely talented, but for one reason or the other, we either don't call upon them, or we have some sort of biases or some simple reason why they're not given the recognition to be placed in the position. Our problem, our fundamental problem, is the way that others think about us. Merit. I've written extensively on the concept of a meritocracy. And I feel that once people start to believe that people have been appointed on the basis of merit and not looked at because of some transgression at some point in time, whatever it is, you don't have Jesus Christ, who is not the judge in any court in the world. You see the challenges in the Supreme Court in America with the manner in which you're appointed. Even England would have its own problems. And when we're being pure and holy here in the Caribbean or the Caribbean region, we have to always remember that merit is also very important. So I suppose that our people will at some point in time become a lot more confident. We have had some referendum, and we have had one in Antigua when they're saying, hold on a while, not now, not now. I've had some statements from people there who've indicated to me the reasons why they don't want to be part of the CCJ. We've had it in Grenada as well, and it didn't work. To some extent in St. Vincent, it didn't work. I think the confidence now is very important. The push and the promotion on the issue of history and on the issue of things like colonialism, I don't really think it is working. I think we should focus on merit. Our judges also have a responsibility to demonstrate outside of their own, the judgments, by writing, by presentation, by doing other things. There are issues in the Caribbean, economic and otherwise, because there are courts in its original jurisdiction where those judges can, for the most part, make presentation, talk about the treaties, talk about how it relates, talk about how we can trade, talk about how we can get out of these challenges. There are so many things to promote and project the court. And I think merit is what's important now more than anything else, not colonialism. It didn't work. I was making a presentation in Barbuda, and I spoke about the history of Antigua, how the people were treated. I spoke about the advent of UE and the other institutions in the Caribbean region, how they have been able to develop and do very well. And one lady asked a question. So is it because they have done well in the CARICOM region that we must vote for to have the CCJ? You know, we want independence of mind and thought. We want objectivity, proximity to politicians, or the apparent to perceive proximity to politicians by judges was something that pervaded their minds and their consciousness, and therefore it actually affected adversely the efforts to have the CCJ being introduced in Antigua, and the same thing in St. Vincent and to some extent Grenada. So I think that the focus must now be, whereas we recognize that we are going some places, our people. Look at our people in the Caribbean, and there are lots of people in the Caribbean with the ability. And I'm not talking about the CCJ only. I'm talking about the respective courts in the Caribbean. We have to see ourselves as one people. It can't only happen in the OACS. It can't only happen in the CCJ. It has to happen elsewhere. And I think once we recognize that and recognize our abilities and respect our abilities, I think that we will reach much further, and the court will reach much further. It will make a great impact as I'm speaking now, but I still have some hope for the best of the CCJ in the next 20 years.
Dr. Lewis, if I may just, from where you left off a while ago,
Yeah.
Because in the last 20 years, it's quite evident that the court has delivered some high quality judgments and instilled confidence in the quality of the judgments and started to, to build that jurisprudence. Although some may say that the jurisprudence is fragmented because you only have 4 of the CARICOM member states subscribing to the CCJ as its final appellate court, while the remainder still go to the Privy Council. I think that what is needed is the mindset have to change, the narrative have to change. Right? In Grenada and Antigua, we have had referendums, but I think there wasn't the understanding, it became politicized, and that deep understanding of what is the role of the CCJ, the function, the jurisprudence moving away from colonialism. I don't think that the people understand it. In terms of the CCJ drive, is there a drive now to promote that narrative, to educate or sensitize the people in the Caribbean, so that if, for instance, Grenada, St. Vincent, Antigua go to a referendum now, that they can achieve that 2/3 majority to have the CCJ as the apex court?
I'm not sure. I can't say. I'm not convinced from my experience in Grenada, Antigua, I'm not convinced. The issue, I'm not convinced that the colonial reason is actually gaining ascendancy. It is an issue of trust, and very important. Even though with our mechanism in place, which is better than most apex courts in the world, where we have the CCJ financing the court, where the government do not finance the court, people still have a problem with trust. And we have to look at it from a political perspective as well. Always remember that for the most part, the masses put governments, put political parties in office. And the masses, for the most part, they do not sometimes really understand the socioeconomic issues. The masses are the ones in a referendum that will have to vote for the CCJ. So the masses have to be confident. They have to feel that they should trust. And the question is, how do we do that? If at your local judiciary there are problems, you will find that people, they transfer that, unfortunately, to something a bit higher. That is more difficult to get through to them if they have no trust in their own judiciary. But as you say, I think that there is hope. And for the most part, the success of those referenda will depend on the strength of the government. The strength. Because if you are not a very strong government. It means that you don't have the masses supporting you. And it's difficult for you to influence people from the other side who appear not to want to support the CCJ, not because they don't want it, but because it is highly politicized. Supporting it will mean a plus for the government in office. And they will not want that. We have to be very realistic. You know, I've been once a politician, so I've been through that. I've been once a member of parliament, so I understand it. And so we have to understand that we have to build that sort of trust, build that confidence. The judgments alone cannot do it. They will impress us because we read the judgment. We want the jurisprudence. As lawyers, we would need to be able to do that. But the ordinary man on the street, he does not care about that. And how do we get to him? Because without him, we're not going to be able to go to the appellate jurisdiction. And I think there's another issue that you mentioned that I think we must pay attention to, and that is one in which um, in these three territories, the issue of apparent fragmentation of jurisprudence. Um, to what extent will the high courts or the courts of appeal in the countries in the Caribbean, like Jamaica, OASIS countries, three of them, St. Vincent, Antigua, uh, uh, um, um, St. Kitts, and Grenada, to what extent you find that they utilize the jurisprudence of the CCJ? I was in court one day with the matter, and I remember the judge said, I really enjoyed the judgment of Justice Saunders. But to what extent was it impactful if there's a Privy Council judgment that seems not to be the same? So you find that, as you quite rightly said, Mr. Paul, there's this apparent fragmentation. It therefore means that the decisions of the CCJ must now become important in the jurisdictions that are not members of the appellate jurisdiction of the CCJ, and utilized and mentioned as persuasive, and let them be persuasive. But right now, you have in some of the legislation, if the country does not have a law that deals with this particular issue, the law of England applies.
Mhm.
You have those that have that law in these countries. You also have until the what you call the Independence Day, the common law is used unless it is removed or reversed by statute. So you still, even in the universities, when you teach, because your common law jurisdiction, you find that you have to follow that. So the CCJ will take some time before its jurisprudence becomes so influential and so pervasive that it operates not only in the minds of the lawyers, but also in the minds of the masses.
Could I jump in, Aisha, here?
Yeah.
Yes, Mr. Robinson, because my next question really was for you, but you could jump in at this point.
I just wanted to recall recently that Jamaica's Court of Appeal, led by President Marva MacDonald Bishop, met as a full court. So 9 Court of Appeal judges sitting together, and they were debating the implications of time spent on remand for sentencing. That case was streamed live. To my knowledge, the first such Court of Appeal case, well, the first time I remember seeing a full court of the Court of Appeal sitting in Jamaica, and I could turn to the proceedings in my classroom with students. What were they discussing? The CCJ jurisprudence. So interestingly, in jurisdictions where the CCJ is not the final appellate court, because the court is dealing with pertinent matters to all of the Caribbean, even countries which don't send appeals to the Privy Council, the highest judges in those jurisdictions, the Court of Appeal judges, are paying close regard to what the CCJ says and is doing, and treat those decisions with the utmost respect. Now, of course, as you mentioned, there may be conflict. I wanted to say something, Aisha, if I could, about referenda.
Surely.
The first thing to think about referenda is that these are entrenchment mechanisms which are found in our independence constitutions. And ironically, the provisions relating to the jurisdiction of the Privy Council are amongst the most deeply entrenched provisions in the OECS countries. Jamaica, a little bit different. There are several countries which don't have referenda, but we have most deeply entrenched a colonial court in our constitutions. So part of the challenge we have is a challenge of constitutional frameworks, which made it difficult to, and have made it difficult to decolonize. When I think about the referendum issue, I think referenda, we forget, are elections. We know how elections run. We know you don't run elections and you don't campaign. We understand how elections succeed, and we have seen several prime ministers with very decisive parliamentary majorities fail in carrying forward a referendum on the CCJ. We see much lower voter turnout in the CCJ referenda processes. I think one of the shifts is, rather than a self-blame, is understanding that the referendum is politics. It's a political process. And if we are going to succeed, you need the voters to come out the same way you need voters to come out during a general elections or a local government elections. And you have to figure out what are the structures which we need to enable us to run referenda in ways in which we campaign for people to come out and vote. If people stay home, we will lose. The only way the referenda can succeed is if voter turnout increases, because the natural instinct is for those with negative views to feel empowered to come, and those who are ambivalent or don't feel strongly to stay at home. But on election day, many of you are familiar with, I certainly know what happens in Jamaica. Somebody's going to come and knock on your door if you haven't yet voted. There is a process which ensures that people understand the value of voting for what's going to happen next and encourages people to vote. And I think we must shift our approach to the referenda so that we understand we're doing politics. It's a political process. Let's think about what are the mechanisms. Do we need a set of mechanisms which attribute campaign financing to the referenda to ensure that different political interests are taking this up in the way in which they would their own candidacy? I think we have to shift our approach. We can't assume people are simply coming to vote because it's an important issue. That's not what we do in elections, and this is an election.
Professor Robinson, I certainly agree with you, and I want to ask from your perspective as a lecturer, what do you do in your classes to engage students with regards to the CCJ? And before you answer that question, I just wanted to let you know, through the comments, we have someone called Youth Advocate, bringing greeting to my amazing teacher, Professor Robinson. Hi, miss. So some students are watching.
Well, hopefully Youth Advocate read CCJ cases in my classroom. So for many of us, I teach constitutional law, and certainly it might be the most important area in which the court has developed the jurisprudence in the appellate jurisdiction, at least. And so, I'm in the middle of marking papers, and there isn't a script which I mark in which students are not referring to the jurisprudence of the CCJ. They're often also referring to the jurisprudence of the Privy Council, and in some cases there's tension between the two. They're trying to work them out, the way in which they will have to as attorneys at law. And so there's several ways in which at the University of the West Indies we think about the significance of this court as an apex court for now nearly half of the English-speaking Caribbean, 5 states. We are wishing Trinidad and Tobago intervene. Not yet happened. It's a jurisdiction which is the most litigious, with the largest number of cases heard by the Privy Council at the moment from the English-speaking Caribbean, significantly more than Jamaica, which is a larger population. But in what we call law and legal systems, there's significant introduction in the first semester of the LLB degree to the CCJ as part of the structure of our Caribbean legal systems. The primary textbook here is one by PVC Professor Rosemary Antoine, and she and many others have been central figures in the early conversations in the academy about the court. And in every course I teach, the jurisprudence of the court is important. And my hope is that that's true for all of my colleagues as well. My students have debated CCJ jurisprudence. The CCJ gave an important death penalty case, Nerve, in 2018. My students debated that decision openly in a public debate. And so there are many spaces in which students come close to the court. The president, other judges, Justice, the new Justice Chantal Ananawu, Justice Winston Anderson, the president have all come through the Faculty of Law, all of the faculties of law, I'm sure the University of Ghana as well. Last year, the president and Dr. Lloyd Barnett sat for a conversation. The president has certainly been in my classroom 3 or 4 times, as he did at Cave Hill. And judges of the court have been in the classrooms of teachers who are offering analysis of our jurisprudence for all of the 20 years that I know of.
Professor Robertson, thank you so much. I think it's very important for us as legal educators to, let's not say push the agenda of the court, but push the agenda of the court. Let students become more aware of what the court is, the functions of the court, and of course, how the jurisprudence has impacted the region. Before we jump into some more questions, and before you have to leave, we do have some questions from some comments and questions from our viewing audience. One question is from Grace. She states, very informative session. Question, I know it was stated that the CCJ is an independent court, but how can we be reassured that the judges will deliver fair and just decisions and not be bribed? And Dr. Lewis is smiling from ear to ear.
She's striving to answer that one.
I'm smiling because that is the common reason. Now, you can't be assured of anything, but what I can tell you for a fact is that it is not he who pays the piper pays the tune. We have a situation in which the court is separate and distinct with financiers. That's the first stage of independence. The court itself. So we finance the court from the trust fund. Then you have the Regional Judicial Legal Services Commission. They appoint the judges, not the government. As a matter of fact, only the president who's appointed by the CARICOM heads, because as he is recommended, or she will be recommended by the Regional Judicial Legal Services Commission and then appointed by the CARICOM heads. So you have a situation which is different to other territories like England or America, where there's independence not only in the appointment of judges, but independence in the financing of the court. Now, insofar as the judgments are concerned, there's also supposed to be the judicial independence as well. Now, there is no connection there, obvious connection. There's no structural or formal connection between the delivery of judgment and the financing of the court itself. A night is there, one, between the appointment of the court, of the judges, and the delivery of the judgment. So I think that is something that we have done, recognizing that persons are very much interested in knowing whether or not the court is going to be independent, or whether or not they should trust it, or whether they should have confidence in it. These institutions, what we call insulative mechanisms, I think are designed to give them comfort that is not likely to happen.
I could jump in here as well. You could also say the proof is in the pudding. 20 years of decisions. And I looked recently at the research of Professor Harold Young, Belizean professor in the United States, who has studied the work of the two apex courts. And there's no evidence that the CCJ is delivering more judgments for governments than the Privy Council does, for example. There's no indication that the CCJ is the court which is far more likely to side with a powerful state. In fact, the opposite. We have very notable decisions in which the court finds for individual litigants who have challenged their governments, and fines against governments in matters of great political importance and significance. And so I think when you look at the decisions of the court, we don't see any indication that this is a court which is not being fair. I think on the contrary, all indications are. We hear a diversity of views on the court. So the court itself often has multiple decisions by its judges. So we hear different points of view, and we hear a court that is willing to do the work we wish our apex courts to do, which is to hold accountable our states, to uphold the Constitution and the rule of law, to do justice between litigants. They don't have to get it right all the time. No court does. So we're not talking about perfection here. We're talking about high quality decisions, and decisions which signal to us that this is a court which is willing to stand up to the powerful.
Thank you so much, Professor Robinson. Before you go again, just some more questions from the chat. Mr. Cyrus Griffith says, okay, a very good session so far. Why some countries still have the Privy Council as their final court? And that was an exclamation point. So he's very passionate. He wants to know.
The first thing I would say is the reason in part relates to how deeply entrenched the court is, certainly in the OECS jurisdictions. And so when you look at the countries that have acceded to the appellate jurisdiction, now 12 countries are contracting parties to the CCJ agreement. That includes Suriname. And the hope is that Suriname will one day also send its final appeals to the Privy Council. But if you take Ghana, no need for a referendum. Barbados does not have referenda requirements in its constitution. Belize didn't need a referendum. Dominica and St. Lucia utilized an alternative mechanism in their constitutions, to my knowledge, which was they sought the agreement of the United Kingdom government to the abolition of the Privy Council's jurisdiction. So an alternative to referenda in some OECS countries, and this gives you, it's one of the reasons why the talk about colonialism is unavoidable. The idea that as independent states, our constitutions provided that we needed a referendum, and in some cases more than a 50% majority, to remove the jurisdiction of the Privy Council, and then created as an alternative that one could remove the jurisdiction of the Privy Council with the agreement of your former colonizer, the UK government. And And interestingly, that appears to be the mechanism through which two OECS countries have accepted the jurisdiction. So the reason why, I would say, remember, the why is partly connected to the level of entrenchment of the court.
Thank you, Professor Robinson. Dr. Lewis, would you like to make a comment in regard to the question?
Well, I commented on that extensively earlier. I've been involved in 3 campaigns insofar as the referenda are concerned, which involved in one way or the other the CCJ. And I've had town hall meetings. I have had meetings on the street in Grenada. And we've had television programs, radio programs, trying to reach the people to indicate to them the advantages of the CCJ. And it depends on the trust and confidence that the people have in their very own. You have to find a way of removing that. Yes, I understand also that the constitutional provisions make it a bit difficult, but if the people really want it, those provisions will not be difficult because they're given an opportunity by a referendum to make that change. And they have been educated largely. The question, as I said, it is usually politicized. It is a difficult thing to appreciate unless you have been involved in it in an intimate way like I have been. And when you're involved, you understand precisely what the problem is. If the people don't want it, if you can't convince them to have it, if they're highly politicized, if the movement is against it for one reason or the other, if you're not able to instill that trust and confidence in the people for one reason or the other, then you're going to have problems. Constitutional provisions are not. Yes, the constitutional provisions will make it a bit more difficult because they're entrenched and require 2/3 majority. But the issue is this, is that the people have to make that change, that difference. Should we force it down the throat of the people to accept it, or should we give them an opportunity to be part of it? That's a question that we have to ask ourselves, whether or not it is democratic to do that. Should we just find a way of just do it, even if the people don't want it? I think also that we have a responsibility, each and every one of us, including the courts, to be able to influence the people in the region one way or the other. When I say one, I mean by not only the judgments, by the way we function, by virtue of merit, by the way we go out and promote it, that here we are. Even the issue of colonialism. Some people, I taught history at one time, and people nowadays are so steeped in the livelihood and so on. They don't. That is not even of importance to them. The people who existed in 1969 and so on, due to the Black Power era, where people were highly mobilized in understanding the colonial challenges, they really would have been far more mobilized at this time to understand the need for the CCJ. We have a different type of people now who have benefited from those movements and who are not influenced by these same colonial challenges, who seem not to care very much about history, but only about their own development. Individualization in many of these nations project people. More people are now having degrees generally. More people are becoming educated. But when they become educated, nation issues, nation building, self-aggrandizement, all of those things become more important than the colonial issues. It's how do we now get our people to come back to recognizing that, listen, we are a free people. We have some liberty. We experience a tremendous number of problems. I'm making these statements because, as I said before, I researched the history of Antigua and made a presentation in Antigua in 2018 on the implications of slavery all the way through, and why is it so important that we take our own destinies into our hands. But it played against. It didn't work so much for. I think, how do we get a chance to get the people to trust us? We have to demonstrate that by the people that we put on the court, by the judgment of the court, and by our own judges in their respective territories. I believe that once we're able to do that, and a government that is very strong, I believe a government that is strong, when it is very strong, is in a far better position to succeed in a referendum than one that's veering towards elections in 1 or 2 years, or one that is not very, very strong. One has to be very careful because it can become referenda very, very highly politicized.
Yes.
And I think that the individuals, we have to get the masses by public education to understand the importance of the CCJ.
Just come in 1 minute, please. Professor Robinson did say she has to leave at 8 o'clock, and in fact, we have 7 minutes past. So I don't know if Aisha, she could just give final comments if she still need to leave, and then I just want to recognize the sponsors after before we continue.
Yes, Professor Robinson. So we want to thank you so much for being with us this evening. Before we leave, any final comments and thoughts that you'd like to share?
I would say it's an interesting moment for the court. So we're talking about it at its 20th anniversary. The president of the court is the only judge who has served for all of those 20 years. He retires in another 2 months, I suspect. We will have President Winston Anderson from July onwards. We have had 2 new judges in the last 6 to 8 months, and we are probably expecting another judge who replaces the president. So it's also another moment in which we are also going to see a court in transition. And so it's also, I think, a good opportunity for us to closely watch the court as it becomes a slightly younger court. And it will become a younger court. I know this will be of interest to Dr. Lewis, who has to worry about the pensions. But I think it's also an interesting moment, especially with a younger Caribbean population, to also notice that this is a court which will be regenerating in the next year, 2-3 years. We may have an almost new CCJ, and I think that will bring interesting developments, which we should also closely be watching.
You muted, Aisha.
Thank you so much, Professor Robertson, for joining us this evening. Truly, your insight has been appreciated. The chat has been very engaging based on your comments and your contribution this evening, and we wish you the best.
And I would just say, Aisha, that maybe the last thing I'll say, and maybe here I'm slightly. Dr. Lewis and I are on slightly different ends. For me, referenda are politics. They're politicized and they're politics. And we must start treating them as political processes if we want them to succeed in the interests of the Caribbean. Take care, everybody. Thanks for having me.
Thank you, Professor. Wish you all the best.
Thank you, Professor. And before we continue, I just want to recognize once again the sponsors of the program: GEM Professional Solutions Inc., GEM FM carrying the program on FM radio in Canada, and also Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Welcome back. Back to you, Aisha and Francis.
So, Francis, I know that I've been taking the mic a little bit here. I just wanted to engage the audience because they've been asking a lot of questions in the comments. And before we continue, I just have two more questions, and these are particularly for Dr. Lewis. Hence the reason why I waited to ask them. One question, Dr. Lewis, is from Mr. Gilbert, and he says, how can the CCJ further establish itself not just as a legal institution, but as a moral compass for the Caribbean, especially in times of political or social tension?
But that's interesting. It can, as I said, firstly, by its judgment, by its reputation. Firstly, you have to command the respect from the powers that be. And then apart from you yourself demonstrating that level of moral compass, you then have to be able to go out there and show firstly by the fairness of your judgment, and secondly, to demonstrate that you are able to speak on very important issues, to write about very important issues out there, so you get the respect of the people. They'll look to you for guidance. They expect you to be able to resolve their problems. Once you function like that, people are always going to believe that whenever there's a dispute, whatever decision you give, they're going to believe that it's fair, even if it may not be in their favor. They may be upset at the point in time when a decision is given, but once you have trust and confidence, and they feel that you are independent, then they will tend to feel that, well, listen, I know that I may have lost, but I don't think I lost because there was something untoward that happened. I think I lost because perhaps there may be a mistake, or there may be something about my case that was weaker than the other person's case, whether by presentation or by factual or evidential issue. So I think that the issue now is for the courts. Can do it by reaching out, not necessarily to project yourself and to say, come to us, we are good, we are reputable, we are able to give good judgment, but by the other things that the judges or the court will do in the respective communities to command the respect, not only of those in the political environment, but those who are the masses on the ground as well.
Thank you so much, Dr. Lewis. And then the final question from Mr. Griffith, Cyrus Griffith. He said, what sort of compensation is there for judges who may not be able to complete their term because of ill health?
It depends on the number of issues. For example,
okay. Before you answer, you are answering just like an attorney. It depends.
It does depend. It depends what you mean by term, you see. The person become pensionable at different periods of time with respect to the amount of monies that they receive. So if you're ill and you're able to complete your term, what is really a term? Your term is up when you reach a certain age. But it meant that you would have been pensionable by the time you reach that age. It's possible that could have happened. So it's difficult for one to be definitive in answering the question that has been asked.
I understand. So, Francis?
Thank you, Aisha. Well, you're the co-host. I'm just the guest host. So that's all right. But Dr. Lewis, we have been speaking a lot about, the public, and in terms of the referendum, particularly in Grenada, St. Vincent, Antigua, St. Kitts, in terms of getting that majority, a lot has to do with the strength of the government and the people, what the people want. So in terms of community engagement, because I know that the CCJ has a strategic plan, I think it was 2019 to 2024. I haven't read it in detail, but in terms of community engagement, is there a specific drive to engage the public in the various states? For instance, whether it's something online, whether it's a pamphlet that can be given out, so that the public out there, even before there is a referendum or build up to a referendum, the public understand, what is the role of the CCJ, what is the function, the integrity of the CCJ, the independence of the court and the judges, because the ordinary man out there, as you say, not interested in things like that until, you know, um, they have a case whereby you think that, there is injustice and you want to jump from the Court of Appeal and go to the Privy Council. But I'm just to add before you answer, in the context of jurisprudence, the Privy Council, the judges are living in England, not in our Caribbean context, not understanding our customs and societal norms. So when they pronounce a judgment, is in that abstract a matter come to before the court, you have a barrister present the case submissions. But in terms of in the Caribbean context, where you have judges who are from the Caribbean, who live in close proximity, who understand the culture, who understand, for instance, you see someone and you say hi love, you don't know the person, but that's normal. For you may say that in, in the US, and someone might say that's sexual harassment. So again, is there any engagement, community engagement for the public to sensitize them to, bolster, build that trust and confidence in the CCG?
I think the CCG itself has done a lot with respect to its documents and promotion and its website and its sometimes presentations. But I think the governments of the day, the bar associations in particular, they also have a responsibility to get that message across. I remember when I was the president of the bar in St. Vincent and the Grenadines, it was organized. Every year we had this annual lecture. And I suppose that we can have those as the features. And when once a person speaks on different topics, for the most part, people will pick it up on the radio stations. Something that is very vibrant in these territories now, you have these call-in programs on so many different radio stations. And they, by extension, educate the masses on issues relating to the CCJ. So I believe the bar associations can take a very serious role, if not the politicians, but the bar associations should play a very, very serious role in educating the people and getting that message across to the communities.
Thank you, thank you, Dr. Lewis. All noted. I have taken note, and I'm sure Aisha has taken note as well.
Certainly, Dr. Lewis. I think the bar associations have to be more active in community engagement. I think people look at attorneys sometimes from the purview of we're here and there at a different level. And so I think programs like these, for example, and having the president of the Bar Association present and even a floor member from the Bar Association and just educating the public this is what we need in order for people to understand how the court works. And this brings me to a comment that we had in the chat too.
Before you go ahead, there's something Grenada has it also, what we used to call an outreach program. We have a week of activities. And during that week, one can make the CCJ and the importance of the CCJ a feature, the prime feature in those activities.
Well, Dr. Lewis, I think you're speaking about our Law Week, which is
our Law Week.
Yeah, we have Law Week, and then we also have one of the longest running lecture series in the region called the Sir Archibald Ned lecture series. This is where we invite prominent legal minds to speak about particular issues and perhaps what we can consider as a exec going forward is for the CCJ to be the topic for this year, especially on the heels of the 20th anniversary. I think this would be
Quite
something.
fit.
Yes, it would be, certainly. Linda Smith says, and this, I waited for this. She says, the masses do not trust the judges, particularly in the OECS, because the masses question the integrity of attorneys. Starts from us. Legal academia should address the issues and gray area that concern the population before governments could attempt another referendum. And this just goes back to exactly what you were speaking about, Dr. Lewis. This whole thing depends on trust, not only for the court itself, but the entire judicial system and the powers that be are the parties that engage therein. So it comes back down to attorneys and all of us remembering the oath that we took, to act with integrity and to do right by clients. And I figure that with programs like these and, the more attorneys engage with the public, we'd be able to, at some point, gain that trust. And hopefully we could attempt another referendum sooner rather than later. So, Dr. Lewis, you've been with the CCJ for a while. I want to know, from your point of view, what is the most significant achievement over the last 20 years that the CCJ has made in the region?
Well, it is, I think, its ability to, I think that case, Shadik Mayer's case, I think that really announced its presence in the Caribbean with respect to freedom of movement. Even though it may not be adhered to, observed strictly to the provisions of that judgment, but still it sent a message. And quite a number of Caribbean people, even those who are not really involved in legal issues, who understand that at least the CCJ is here and hopefully is here to stay. But I think that of everything else, that one case reverberated around the Caribbean and made the CCJ well known to all. I can't think of anything else outside, which is public. Quite a number of things are done in the CCJ to develop it, to expand it, to improve it, but those are administrative matters or judicial matters. But from a public perspective, I think that one matter. So let's extend the case with Guyana and the elections. But for the most part, Penny Myers.
Dr. Lewis, for the folks out there who are not aware of what the Mary case is, Shanik Mary case, can you just elaborate a little?
I think that has mainly to do with freedom of movement. It had to do with an individual from one of the CARICOM countries, I think Jamaica, not being given the same level of liberty that is required by the CARICOM freedom of movement requirements to be able to enter Barbados and to be able to stay there. For you go to these Caribbean countries, you're supposed to be able to be there for at least 6 months, I think, when you enter, unless you enter the diplomat, when there's no precise term given to you. And when you are prevented entry without there being any fundamental serious security or health reasons for being precluded from entering into those countries, it seemed to go against the very fiber of the CARICOM treaty with respect to freedom of movement. So what they're just saying, to put it very simply, is that we must be able to move freely throughout CARICOM because we're trying to present ourselves as one nation without having these sort of instruments of prohibition being actually employed against us. Understandably, if you're a threat to the society, if for security reasons, if you have a problem with respect to health, and every country has a right to try and prevent its citizens from being affected adversely in that way. Understandably, there may well be a reason, a justifiable reason, for not allowing you freedom of movement in that respect. When those things are absent, it is not going to fabricate other alternative reasons to try and prohibit or preclude you from gaining freedom of movement in the territory. So I think that is basically what it was all about. I think that's how people understand it in the CARICOM region. And I think it actually addresses the number of things that people have in their minds with respect to movement. You can't be part of a treaty with respect to freedom of movement and impose these barriers that go against the grain of the very objective and purpose for which these treaties were established.
Thank you, Dr. Lewis.
It is Dr. Lewis. Well, Dr. Lewis, it seems as though you are in front of the firing squad this evening because all of the questions are now coming to you. But do not be dismayed. I have a next question from Mr. Gilbert. He said last question. And he says, in light of the evolving body of Caribbean jurisprudence being shaped by the CCJ, would you say that the court has successfully developed a distinctly Caribbean legal philosophy, one that reflects our unique history, culture, and constitutional realities? Or are we still too tethered to the colonial precedent in the application and interpretation of law? That's a good question.
Well, we're still very tethered. We are a common law jurisdiction. And when we decide cases to a doctrine of precedent, for the most part, we follow the common law. Even our statutes sometimes are pari materia with statutes in the United Kingdom. So we apply the common law here in the Caribbean. And even with respect to the countries that are part of the appellate jurisdiction, even the lower courts, for the most part, they apply that because these are centuries old cases. The CCJ is just coming into being. It hasn't reached a stage yet where its jurisprudence has become part of the judiciary, part of the judicial proceedings, part of our very existence in the CARICOM region. It will take some time before it reaches there. Even though, as we heard from Professor Tracy Robinson, the jurisprudence was discussed at a Court of Appeal level in Trinidad, there's still a magistracy level, there's still a high court level, and there's still a common law being applied at those levels. And there's still the decisions from cases in the United Kingdom that are still applied. You go to train right now, if you trained in the University of the West Indies, you'll be trained using English cases. There are times when you'll use the Caribbean cases, but you still have that jurisprudence hanging over you. You still have to apply it. It will take some time. It's true that they're developing just 305 cases so far at the appellate jurisdiction. There are thousands of cases in the common law which influencing us at this time as persons who are involved in the law. So it will take some time, but it will get there eventually. But again, as Mr. Paul said earlier, the apparent fragmentation of these judicial decisions would create some problems also as to where we are going. Because those countries that are part of the CCJ may wish to apply the jurisprudence of the CCJ, and those that are not part of the CCJ, this appellate jurisdiction, will have to apply the jurisprudence of the Privy Council. So you see, with this sort of, unless they are parallel, where there are conflicts for countries that are not part of the CCJ, you have to apply the jurisprudence of the Privy Council. So where there are conflicts, again, you have to apply. There may well be parallels. I don't know. The fact is that it will take some time before the CCJ's jurisprudence can impact and become pervasive in the CARICOM region.
Thank you so much, Dr. Lewis. I certainly agree with you. So you've given us the history of the CCJ. You've told us about the establishment. We've talked about some of the challenges of the CCJ, and we've also talked about some of the significant milestones since the inception 20 years ago. What I want to know from you and from your point of view, where are we going in the future? What does success look like for the CCJ within the next 10 to 15 years and the next 20 years?
Success depends a lot on existence. Existence depends a lot on finance. Those of us who from a cricketing background will know, if you're not in the wicket, you can't score runs. And for you to be in the wicket, you have to be selected. You have to be given the opportunity. Now, to be in existence would mean that you have to be able to be financed into perpetuity. So the very first important issue is being in a position where you can continue the jurisprudence, continue to influence. It all depends, to my mind, from my background as a CCJ, on the governments recognizing the importance, which they already have done, of injecting a bit more, let's say about 50 million, as they've promised, into the fund to enable the court to continue for a long period of time and not for its existence to be threatened. That's the very first thing. Where we go from here, that's the very, very first issue. If you're confident that we're able to be financed, then the next issue is the ability of the bar associations and the politicians to influence those people residing in those countries that are not part of the appellate jurisdiction of the CCJ, to influence them to recognize that, listen, this is what we want as our apex court. We don't want to be part of the Privy Council anymore. We want to be part of the CCJ. They have to make that determination. The 20 years from now will depend largely on how the people in those territories that are not part of the appellate jurisdiction, how they see the CCJ within their own judicial scheme of things, and also on the ability to be financed for that period of time. So I can't say it is glim. I can't say it is dim. I can't say that it's extremely bright. What I can say, there's a lot of hope that this institution will continue to be in existence for the next 20 years in a way that will help to improve the lives of our people via jurisprudence. And that's a realistic and practical response to the question that you've asked, because it's you can only exist if there's fuel. A vehicle can only drive as far as it can, depending on the amount of fuel that it has within its tank. And that is what gives it the energy. And we hope that very soon the CCJ will have that, continue to have that energy to propel itself into the consciousness of those residents or those nationals of the countries who are not part of the appellate jurisdiction.
So, Dr. Lewis, certainly we can say that the future looks bright once the pockets are filled.
Are replenished.
and that is certainly fair, given everything that we've discussed, especially about the funding of the CCJ. I do recognize, though, that one of the major challenges that the CCJ has is one single word, and it's trust. Getting trust or gaining trust from the public in our jurisdictions, and I think that is something that we would have to work on. Francis.
Because I just want to ask a question.
Yes.
There was this case that went before the CCJ, British Americans / CLICO.
Yes.
And there are many people who are of the view that it was an opportunity lost. I know there was this disappointment in the decision, and as eminent a person as Dr. Kenny Anthony, on this program, in fact, uh, he, but of course he had some criticisms of the decision. But he was saying that in terms of reform, he considered that there may have been a problem because you are dealing with an issue like with the British American matter. It was really about the Treaty of Shannon-Ramos, cross-border issues and all of those things, cross-border financing and cross-border transactions. And I think he expressed the view that maybe the court needs to look at the issue of specialized panels to treat and deal with matters as those, so as to increase the confidence in terms of the outcome. Now, shortly after that, I think the new person from Jamaica, in fact, is someone who is specializing in treaty law and international law. So I just don't know if you want to respond to that issue.
It's a very interesting point, and I'll tell you why. Because it falls squarely into our own views as to how the court should be structured with respect to judges and the appointment of judges, mainly for the purpose of ensuring that the amounts of money that are paid out will not create a problem, especially in situations where judges retire and are still alive, so you're paying two persons at the same time as opposed to paying one person. We have a similar approach. We are thinking that do all of the judges, should they all be there in Trinidad? Should we have judges who are not residing there, who can be called upon to use their specialization to sit on certain cases for which they have the ability and the expertise? In that way, you can reduce the amount of money that you pay towards judges, salaries, and pensions. It's something that we've discussed extensively. And it's rather interesting to hear Dr. Kenyan, mainly because of this matter, is indicating that perhaps that is the way to go. For that matter, but we have been discussing that way to go for the purposes of ensuring that the court is being financed into perpetuity, where you have a situation where 80% of the total amounts paid to the court will go towards salaries and pensions. So I think that I share his point of view, even from a different perspective, because these are specialized matters. They're matters that impact not only on persons in respective territories, cross-border transactions, as you quite rightly indicated, the implications for the treaty as a result of those. And it is one thing to have practical judges, another to have an academic one. And when you can find both, then you're very lucky. And that is something that we should really think about very, very carefully. I think that the time has come when perhaps we should start thinking about having judges not necessarily being based in Trinidad, but being called upon for the expertise to use to determine certain matters. I understand, Mr. Layne. I think that's a very good point.
A second issue, and I'm kind of piggybacking on something from President Saunders, probably appeared on last week. There was this case in St. Vincent, which you well know of, the Shanique Hall, that's the name of it, versus the Minister of Health. The COVID-19 case, we call it.
Yes.
Right. Yes. And as you know, it has to go all the way to the Privy Council.
Yes.
And the challenges with that. Yeah?
Yes.
And he made the point, not directly, but I want him to be saying that he made the point that, listen, the question of access to justice, the question of access to a final court, and he just said that maybe people in St. Vincent Law maybe regretted that they have not gone that way as yet. And I understood it to be a reference to the difficulties of going to the Privy Council,
Yeah.
included in a matter as this. Now, do you believe that the issue of access and really getting home to Caribbean people, the importance of access, could in any way assist in this process of seeking to convince people of the need to move away from the Privy Council to the Caribbean Court of Justice? Because I take the point entirely about the coloniality. I don't think that's an argument that is working, and for many reasons.
But you know, Mr. Layne, that issue of access was exhausted in the Antigua referendum. It was mentioned, figures were quoted. There were some fantastic and splendid and excellent presentations about that issue. Because access, obviously, to justice, to my mind, is far easier going to the Caribbean Court of Justice. But it's a mindset of the people. Do they think about access when they feel that they have been wronged, even when they feel that they've been wronged by the powers that be? Do they focus on access or just justice on the basis of trust and the belief that there's some independence? The problem that we are going over very easily is one that is embedded in the consciousness of our people. We have to find a way of removing that. The issue of trust. How do we get our people to trust one another? And that has a lot to do with how we treat one another, what they see and what they perceive from that treatment, the opinions that they make on the basis of the facts and the factual evidence that they find before them. Are we in the legal profession? Are we in the political field? Are we doing what is necessary to engender that trust, to create that avenue to which people can feel a sense of comfort that going to the CCJ will give to them as they feel when they go to the Privy Council? It is a difficult thing because I've always had this response to me. Well, they're far away. They didn't go to school with one another. I heard Professor Tracy speaking, and you know, I can appreciate that about going to the University of the West Indies and so on. That's something good or something very bad. Because that is the very issue that people are using to say they don't want the CCJ, that they all went to school, they're all friends and so on, and so they're likely to rule in their favor. That is a two-edged sword. It's an area that I am always fearful to trod. It's a path that I stay clear of in these discussions as to why we should go to the CCJ. The answer is always the Privy Council is far away. They don't know anybody. They don't care about anybody. They're not being paid by anybody. I mean, they're not going to lose any job as a result of any decision that they make. Nobody's going to dislike them. They're not living here with us. They're totally independent. Now, that is a feeling that you have to remove out of the consciousness of the people. That is trust. So I'm always very wary about all of us going to this school. That's a minus. It's about merit. It's about fairness. It's about justice. It's about equity. That is what it's all about. It's about comfort. And in the end, they all will give rise to trust. It's about independence. Now, I think that we are skirting over these things with academic arguments. No matter how good your article could be, no matter how wonderful your presentation is, unless you're able to tackle with what is within the consciousness of the people, the problem of trust, unless you do so, you're not going to get very far. And I think based on the question that you asked, I think that the time has come when everything is protruded towards removing the problem, removing the problem that we have where the people are saying the CCJ is distant, but we aren't. And therefore, we can get justice there. And when there's a decision, they feel a lot more satisfied, I can assure you that perhaps if that decision was given by the Privy Council, the one with respect to the British American case, people feel a lot more satisfied. People a lot more diligent, which is very good. They will be a lot more diligent. They will peruse more diligently the judgment of the CCJ than they would one of the Privy Council. The people will accept the judgment of the Privy Council, but the very people, the ordinary people, would question the judgment of the CCJ if it doesn't go their way. Very much the same way in the British American case. I'm not saying that there are good reasons for that. What I'm trying to tell you is that people seem to have a lot more trust in the abilities and the objectiveness and the independence and the fairness of the Privy Council judges. That is a reality, but we have to try and remove that.
Mr. Lane?
No, you Aisha, that your advices.
Great.
I just wanted to add, Caribbean people, they say everything that comes from England is good.
Yes.
CCJ is based in England is good. And they say, anything come from CARICOM is inferior.
Yes.
So it's a mindset again.
That's the
Mindset
point.
that has to be changed with
Yes.
engagement.
Really, absolutely correct. And it has to be constant, not only when there's a referendum. It has to be constant, something that has been discussed. But over the years, we have come to accept our own Caribbean people in being able to manage us and so on. But we still have a very long way to go.
So, Dr. Lewis, I've had discussions with persons, lay persons who are not legal persons, and one of the issues that they have is that they do believe that the CCJ itself is closely tied to politics. Of course, it comes back down to everything you said about trust, right? But do you think that the issue of the CCJ becoming the final court of appeal should be more pushed, not necessarily by governments per se, but private institutions or private persons, meaning, for example, just like you said, the bar associations or let us say a particular institution, etc. Because I think the political landscape, that's what's really causing the difficulty or people trusting it, especially particularly from the Antigua point of view, because this conversation would have been with some Antiguan friends of mine, and that was the difficulty. Would you agree that you should move away from the whole political, I mean, at the end of the day, it has to be a referendum, yes, but rather than the government itself encouraging persons to see the value in the CCJ or to push the CCJ as a final appellate court?
The question is this: would you also agree with me that our countries are so highly politicized that the institutions to which you refer may also be politicized as well? And that is why the Bar Association should take up the mantle and have these discussions with these private non-governmental organizations from a sponsorship perspective to engage in activities and so on in the respective territories, in areas where people need to understand the nitty-gritty of the justice system and the extent to which not only would they have very easy access to justice, but also they like to have the same type of justice coming from the very own people. That is what needs to be done and needs to be said. We have our people managing our own people. We have our own governor generals, we have our own president, we have our own prime ministers. The people have grown to trust their very own. They've gone and they've sought independence, and the people have voted for independence. And now that they're independent, they're very happy and they're pleased about it. So there's some trust in the abilities of those persons who were able to be our founding fathers. It may have taken some time. If you understand the history of slavery, it took some time to develop that trust amongst oneself. And it will take some time also to develop that trust within the CCJ. It is not going to be easy, but how we treat ourselves will be indications of how others see us. As I say, we must appear to be running or functioning on a meritocracy. We have to be seen to be benefiting people or pushing people or awarding people on the basis of merit. We have to stop looking for the slightest thing to pull someone down or to prevent someone from getting something that person deserves. The person with the ability to do that. If we continue to use every blotch against an individual and hoping to find someone like Jesus Christ to be out there to project us, we are never going to have the people with the ability to be able to project us. And so, of course, there must be some moral compass. Of course, there must be some reputation, some reputable standing. But at the end of the day, we have to also temper justice with mercy. It's not what we like. We don't just promote a person because we like that person, notwithstanding the fact the person doesn't have the ability at all. And that is, some people in our territories see things in that way, and they complain that things are being done in that way. And so they have a problem with the judges in their own territories. If they have a problem with the judges in their own territories, they're going to definitely have a problem with the CCJ, because, as it said to me in Antigua, those same very judges are likely to go on to the CCJ. So if they have problems with them now, and they have possibilities of getting there, they say, "Oh, not now, some other time, later on." That is the reality. We cannot go away from the reality. We can't be academic about it. We have to try to resolve it practically by getting people to trust us, one way or the other.
Thank you, Dr. Lewis. Before we wrap up the program this evening, I just wanted to read some more comments that we have from the chat, questions. We have Dave Ned. He says, the answers to the question, read failure, will only be revealed when we look at the bill that was presented to the people. The bills all went beyond the stated mandate of assenting to the CCJ. Karen Roden-Lane says, I think as long local judicial within the region takes so long to deliver justice in a quicker manner and avoid the backup of cases, persons would not have the confidence in the CCJ being the final court. So essentially, if the appellate courts or the high courts take so long to deliver judgments, persons would be more confident in the CCJ being the final court. Sonia Nixon says, just like it was expressed in Trevor Renault's play, Old Story Time, where the mother believed that her son returning from London, where she said, nothing black, no good. Sonia also says, same, so we have little trust in our products, material, professional, or otherwise. Education is important. I agree, Sonia. We have proven over and over that we are capable and superior. I agree. And one more comment from Sonia. Furthermore, only we understand our cultural and social idiosyncrasies. Time to move to the CCJ as most superior court. So those are the comments from the chat. I think it has been a very engaging session, particularly with the persons on the chat. Oh yes, and one more from Youth Advocate. This is in relation to the Mona Law students. She says, they're exposed to the jurisprudence of the CCJ. Most fascinatingly, their role in the regional legal decolonialization project and the promotion of gender-sensitive approach, just like Professor Robinson had stated earlier. So with that being said, Dr. Lewis, any final thoughts?
Yes, my final thoughts is I want to congratulate the CCJ on being able to exist for 20 years, doing very good work. As a matter of fact, the structures are in place to keep it going very, very strong. Efforts have been made by respective presidents to improve the machinery, to improve the administrative mechanisms that will assist in improving the judgments. And the recognition is growing. They're only there for 20 years. The Privy Council has been there for a long time. And it will take some time for that trust to be developed. It won't develop overnight. It is still young, and it is done well. Over 34 cases in its original jurisdiction, over 305 or so cases in its appellate jurisdiction, and it is growing. The more territories come on board, the more cases there will be, the wider the jurisprudence will spread, and I suppose the entire issue about trust will become pervasive. Until then, it is advisable that the court continues to do its good work, not to feel despondent by the apparent reluctance of some states to come on board. They will eventually come on board, but it is advisable that the CCJ continues to work along, to trot along, to produce very, very good judgments and to gain the respect of a very reputable apex court, not only in the Caribbean, but in the world. I congratulate.
Thank you, Dr. Lewis. I certainly join with you in congratulating the CCJ. Mr. Paul, any final words before we end the program?
Yes, I just wanted to thank Dr. Lewis for a very, very informative session. I mean, I too learned a lot from the session. Also like to thank Mr. Layne for having me as a guest host here this evening. And Dr. Lewis, what I want to assure you that as long as I'm president of the Bar of Grenada, right, I will continue because the Grenada Bar Association, one of its mandates is public legal education. And we take it very seriously. And now that you have given us that advice, I can assure you that the Grenada Bar Association will take up that mantle to sensitize the public of the CCJ, the integrity, the judicial independence, so that we'll be an advocate. I can say that. I can assure you that. Right? So rest assured. And again, congratulations to the CCJ on its 20th anniversary.
So
can we just recognize the sponsors before we end?
Yes.
Just Professional Solutions Inc., JMFM carrying this program on FM radio out of Canada, and also Grenada Technical and Allied Workers Union. G-Town.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Again, thank you so much to all of our sponsors this evening. I'll let Mr. Layne have the final word. Again, I just wanted to thank you, Dr. Lewis, for your time. I would also like to thank Professor Robinson as well for her time.
Yes, okay.
Mr. Paul. And Mr. Layne, you have the
Yes.
final word.
So I just want to thank everyone. Thank you, Dr. Lewis. Thanks to Professor Robertson. Thanks to the viewers. Thank you, Francis, Aisha. Thank you, everybody. Thanks to the sponsors once again. Good night and until next week.
Good night, everyone.
All right, good night, everyone.
Okay,
Right
bye.
now.